All rise. The Lawyer of the Apes is now in session. How's it going, everybody? Welcome to episode 9 of Lawyer of the Apes, protecting your best investment, yourself. Now, why do I title this episode that? Well, the purpose of this episode is for anybody, whether you're a content creator or even an individual person that might be interested in how to protect your investment and yourself if you have a brand. It's very important that if you do have a brand, you protect that brand, especially when you're going to be promoting it on Twitter and social media. Other individuals will try to copy your account, will try to pretend to be you. And one of the things that can really help you avoid that type of behavior is to actually trademark your name or logo. It'll actually go a long way in helping you validate who you are, and I've seen it help clients in the past actually get verified by Twitter, because Twitter lawyers don't want to deal with the possibility of receiving cease and desists for trademark violations. And Twitter actually takes trademark violations very seriously. If you check out their FAQ and you search for trademarks, you'll see that they actually do consider trademarks to be a pretty serious thing on Twitter. So trademarking yourself, your logo, or your name is a good idea for protection. And I think it could also help you with dealing with issues on Twitter, Instagram, Facebook, and other social media. It goes a long way. This is not legal advice. This is for informational purposes only. If you are interested in further information, you should contact an attorney. But I am going to go through and show you the process for informational purposes on how to trademark your name. Okay, so I'm just going to use myself as an example. I'm not going to call any other YouTubers out in the video, but basically these are the steps that I would do. So you say to yourself one day, oh, I want to do YouTube content. I want to start a YouTube channel. I want to have a Twitter page, and I want to get my name out there. A couple weeks later, everything blows up. You're a success. You have so many followers, you have tons of views, and then all of a sudden everyone starts to copy you. People start using your name in other ways. You have merchandise that you're trying to sell, and people are selling merchandise with your logos on it, and you want it to stop, but you forgot to do something. You forgot to trademark yourself. You forgot to protect your name. You forgot to protect your logo. Now, there is an argument that could be made that you were the first person, right, to publish your logo or your name on Twitter, and that could help you prevail in a lawsuit against somebody who's trying to copy you. However, that road is much more difficult than having your name trademarked and protected, because at that point there's no arguing about the timing of everything, and whether or not the logo is actually protected or whether your name is protected. So it's really important to, I know these things happen very quickly to a lot of people, but it's important to consider this. Even if you haven't done it yet, it's still good for going forward. Like I said, for protecting your name and your interests. So how would you do this? How would you do it? So, all right, so let's take, Lawyer of the Apes as an example. So I decide that I want to create this page and name and YouTube content. So I say to myself, all right, how do I know? First thing you want to ask is, how do I know that this name isn't already taken, right? So you go to the United States Patent and Trademark Office website, uspto.gov, and then you do a trademark search. So you would you go to this page and you would search the trademark database. Here, they give you a bunch of options. You can search for a name, you can search for a word or a design, word and a design freeform. So there's two different types of searches for images. Images are, are logos, basically. So if you wanted to make sure that you're not copying any logo or using a font that's protected, for example, a very popular font is the UFC, right? They have a very popular font, and a lot of people will use that font in their logos, and that could technically be a violation of trademark. So you have to just make sure that when, depending on what font you're going to be using, it won't, raise any red flags, during the process of approval of your mark. So for me, I'm not going to go with a logo. I'm not going to be using a logo. I'm just going to be using a name, and the name of the YouTube channel and Twitter handle is going to be Lawyer of the Apes, and I want to protect that. So I would go to basic word mark search, and I would, right here in the upper left, you see it plural and singular. You want to search both ways just in case someone puts an S at the end. So let's say, I create a Lawyer of the Apes, and then somebody says, oh, I have an idea. I'm going to be Lawyers of the Apes. You want to make sure that, they're basically the same, so that they can't try to get around your name by pluralizing it. So same thing, when you're searching for the name, you want to make sure that nobody has a name, whether it's singular or plural. Live and dead. Okay, so here you really just want to make sure if they're live, currently live, on, active, and pending a trademark. If they're dead, that means that they're no longer, seeking the trademark, and you could go after it. But we'll search for both just in case, because I really know at the end of the day, nothing is going to come up for this. So I'm going to check it. Lawyer of the Apes. So I type in Lawyer of the Apes and I submit query. Okay, so as I suspected, there's no record that matched the criteria of my search. So therefore, I know that nobody is currently trying to trademark the name Lawyer of the Apes, which is good for me. So now that I know that nobody is doing that, what do I do? Okay, so I go back here to the front page of the United States Patent and Trademark Office, and what you need to do is you would go to click to apply online, and then you have to actually register. So you would log in with your name and your email address, and then you would register with the trademark office, and then they would allow you, I've already logged in, and then they would take you to a page that looks like this, where you can fill out the application. So this is the application. Oh my God, it's like, oh, so it has all this fine print and all this crazy stuff. Basically, it's a really, really easy application to fill out. All you have to do is, know what you're doing, or at least have a basic idea of what you're doing in order to, do it very smoothly and without having to deal with the lawyers at the trademark office reaching out to you for additional information. The more information you can provide during the initial application, the better, mainly because you won't have to deal with the attorneys and their questions after the fact, but also it'll save you about $100. So if you have all the information that you need, and you're going to be able to answer all these questions and provide all the relevant documentation, then you can select the TEAS Plus application, which basically charges $250 for every class or good or services. Now, standard application is $350 per class. So that means basically you don't have all the information now, so you're going to have to come back at another time. So I guess for the additional processing, they charge you an extra $100 for having to deal with the attorney. So what is the big difference between Plus and standard? Okay, the only true difference is when you submit a application for a trademark, you have to prove that your trademark is being used in commerce. So that means, for example, if you're a YouTube, promoter or a YouTube influencer, you have to be able to show that not only you're streaming on YouTube, but that you're also, in the stream of commerce that is making money. So you would basically have to submit some type of proof of receipt that shows that you're in the stream of commerce. Submit another sample you could submit. Along with that is the actual YouTube link to your page to show them that you are active on YouTube. So that's basically the big thing that you need to show. You need to show. So, and if let's say you're not a YouTube influencer, you're an ape who's created logos or slogans, and those slogans you're putting on T-shirts. Same thing. You would have to show that you're in the stream of commerce. Show them that there's a website, where you sell the shirts, and that you have receipts establishing that you've been making money. You can't just buy the names and not use them. They want some showing that you're actually going to be using the names for some type of purpose. Now, also, I'll note here, it says here, they charge you per class of goods or services. So, for example, each and everything you're going to do with your name, logo, or image, you have to pay for $250 or $350, depending on how much information you have. So let's say you're a YouTube influencer, but you also have, a merch shop. So you would need to pay $250 to protect your name under YouTube influencer or vlogger. And then you would also have to pay another $250 for another class of goods, which would be merchandise. So then the total you would have to pay is $500. Now it's potential that there's multiple other classes or goods or services that you might be doing with your name and logo. So you have to pay $250 or $350 per thing that you plan on doing with it. Okay, so that's important to consider. So it can get a little bit expensive, but the protections are worth it. All right, so next they ask you, is an attorney filing this application? An attorney does not have to file this application. Anybody could do it. It's not rocket science. The only time an attorney has to do it is if it's a foreign domiciled owner of the mark. They have to have a U.S. attorney represent them. But that's it. That's the only time an attorney is required to file this type of document. You as an individual owner can do it. So then, now that we've established this first page, what I would normally do is I would click continue. All right, they're telling me I have too many browsers open, whatever. All right, so wait, why is this not working? Sorry guys, give me a second. Okay, here we go. So then it will take you to this page. All right, so this is where you have to fill out the information. So I'm going to fill it in as if it was for me. So owner of the mark, I'm not gonna put in my real name, obviously. I'll put Lawyer of Apes. None of this is gonna go through, but so here they ask you what type of entity you are. Are you an individual? Are you a corporation? Are you a limited liability company? Are you a partnership, limited partnership, joint venture, sole proprietor, trust, estate, etc.? So here they want to know what you are. Now, my suggestion is, and I don't know, where everyone's at, but my suggestion would be, for informational purposes only, is that if you are going to be on YouTube and you're going to be putting yourself out there, do not do it as an individual. You should definitely incorporate. You will protect yourself from a lot of personal liabilities, potentially, if you file as a corporation or limited liability company or a partnership if you're working with other people. Filing it as an individual is never really a great idea. Filing as a corporation is another thing that's very easy. It's state specific, so I can't go through every state's corporation filing requirements, but that's also something that you can usually find very simply on your Department of State's website, and it's usually a very easy process to file for incorporation, and it's usually a very low filing fee. So that's easy to do. So corporation, we'll say that we're doing it as a corporation, and then here they'll ask us what kind of corporation you are. So they'll ask you what state is it incorporated. I'll just choose a random state. I chose New York. So then they ask for a mailing address. I'll just put in a random address. All right, city. Okie dokie city. I don't know if they're going to call me out on that. And just get to the other page. We'll see. 11564. Made up, all made up stuff. Email address. Lawyer of the Apes. All right, so that's basically that. You can also put in your website address or your YouTube link if you want here. So then as you put all this information in, you hit continue. Let's see if it lets me get through with the fake information. It said they want me to put in a phone number. You can do that. That's fine. I didn't do it, but you can. So here we go. We're on the next page. Okay, so here is where they want you to enter the mark, which is your name. So the mark I want to protect is Lawyer of the Apes. Now, if you wanted to, this is for a standard character mark, right? Which is just my name. I'm not trying to, get the specific style or design. If I chose that, I would put in, I would have to upload a picture of the image, and then I would have to describe it very specifically. So that's basically what you would have to do. Okay, so now we're gonna, as it says, additional statement section of this form is used to enter various legal informational statements that pertain to the mark. For example, disclaimer or English translation. Because you are filing a TS Plus, you must enter the following, if applicable, within the facts of your application. So this is just a standard boilerplate language that they want to add to the mark. So you have to be able to fill this out. No claim is being made to the exclusive right to use blank apart from as the mark shown. Active prior registrations, there are none. So yeah, so this actually you do not have to do. So we'll just skip that part. You do not have to do that. The attorney might ask for additional information later, but we're not doing anything in here that is relevant to this. So there's no prior registrations, there's no translations, there's no transliterations, there's no consent of an individual identified in the mark. So let's say, I use a name in here, like Eddie of the Apes. You would have to sign off saying that you have the consent of the individual, even if it's yourself, to use the name Eddie in here. So that's basically what that means. Okay, so here is where they want you to add the goods or services that you're going to use. So you click add goods or services. So then you want to search for a word for what you're going to be doing. So let's try blog. So here, so this came up, online video journals, namely vlogs, featuring downloadable videos in the field of blank. So that's perfect for me. So vlogs featuring non-downloadable videos in the field of, and I'll have to fill in the subject matter, which would be legal information. And if you're doing finance, you would type in financial information. So I'm going to click yes for this and then insert the checked entry. They want me to, they told me that I have to fill in the information. So I'm going to type in the word law, like I said, insert. Okay, so here we go. So now we have the class set up. It's online video journals, namely vlogs featuring non-downloadable videos in the field of law. You would fill in whatever you are, streaming about. And here they ask you to identify whether or not you're using the mark. So here, section 1A filing, actually using Mark in Commerce Now, which means that you could prove right now that the mark is being used, right, through the proof of YouTube videos or some type of image of merchandise, and also receipts showing that there have been sales. No use of market, intending to use. That means you haven't used it yet, but you plan on using it in the very near future. And then these are for foreign applications. So we'll go with 1A, actually using them. Well, I don't have any proof to upload, so I'm not going to go with 1A because I don't want them. I want to be able to try to get through the whole application. So I'm going to choose no use of market, intending to use. So I assign the filing basis. Oh, I have to click this, sorry. You click that you accept the terms, assign filing basis. Now remember, by doing 1B filing basis, that means that's going to probably take me outside of the TEAS Plus application, which would be 250, and that will now be a 350 because I don't have all the proof yet because I have not started using my mark yet. So if you do have all your proof and you are using your mark, that is a TEAS Plus application, which would be a 1A filing status, and a 1B status if you don't have all your information, but that's a TEAS regular application, which would be $350. So then here they ask for attorney information. I had said that there was an attorney in this. If you don't have an attorney, then you don't have to fill this section out. I'll just pretend like I do have an attorney. If you do, you should. I know you can do it yourself, but you don't have to if you don't want to. So you can hire an attorney. An attorney should not be charging you a significant amount of money to do this. It's really like, just filling out this online form. So if you do hire an attorney, make sure you're not, being taken for a ride. But if you don't want to use an attorney, if you don't want to appoint an attorney at this time, return to the first page of this form by clicking the hyperlink term instructions and navigation tool, answer no to the wizard questioning, is an attorney filing this application? Click on the continue button at the bottom of the instructions and return form then. The attorney information page will not appear. So again, I'm just going to fill it out. I'm not going to go back for the sake of going back. I'll just fill it out, put the name, made up name, Joe Schmo. Bar membership, make up a year, admitted in 2012, and the state of New Jersey. Membership number, just put NA. Good there, street address, 82 Roll Lane, Lawville, Colorado, United States, 1, 2, 3, 4, 5. United States. Email again, lawyer of the apes. Phone number, I know they're gonna ask me for that. 3, 4, 5, 6, 4, 3. Okay, so then after all that information is in, you would click continue if you have a lawyer or if you're having a lawyer doing this. They want me to provide a secondary email. Just making this up. Okay, so you would provide a secondary email here. Okay, so now we're at the final page. So it's saying how many classes were there. There was only one class I selected. I selected vlog, which was class 41. Again, if you wanted to select more classes, you would do that. And then you would get charged $250 or $350 per class. Here, you have to sign the declaration form. You would sign all this information. You would sign off on this. You would use your sign with signature, and then the date signed. Basically, this is the second to last page. So they want you to read these statements, the declaration, read the following statements before you sign it, acknowledging the statements by clicking the boxes below. So the basis, you're saying that you know and understand the filing basis you've submitted it for. You're submitting everything, you know, with knowledge. You have information and belief that the factual evidence made is true, that you're not lying about anything, and that any type of willful statements can get you in big trouble. Okay, so that's all common sense, I would hope, but you never know. So make sure you do read this in great detail before you do so. So basically, to sign off on this, you would do Joe Schmo, the date signed, which is today, signatory's name, Joe Schmo, attorney record. You don't have to put attorney of record. That's if you're using an attorney. If you were an attorney, you would put owner. You would put your phone number. And then you would click validate. I don't know if they're going to buy this because it all looks fake, but we'll see. Okay, so they took me to the real final page, which is here. So here is where you can review everything. So here you would click input, and that shows you all the data you input. The mark, you click this, and this shows you the mark that you are submitting for. So you double check and make sure you spelled everything right. This is a text form, et cetera, and so forth. You check the emails that you submitted. You once again verify, you know, all this information and certify things that you're telling the truth. And then here you would click pay and submit. And then after this, you would enter your credit card information, and then you would be on your way. So after you file this document, you'll receive a confirmation email from the United States Patent and Trademark Office. They'll let you know that everything is submitted. So basically what happens after this is the following. One, if you filed as a TAS Plus and you submitted all the relevant information, you won't get any questions from the attorney, and you'll be able to have your trademark registered within it usually takes about 3 to 6 months. So usually what happens is they get the information that you submitted, and what they do is they publish it. They publish it saying someone is trying to protect the name Lawyer of the Apes, and people will then have 30 days to object, to say, oh no, that sounds too much like Joe of the Apes or some other name. If people object to it, then the lawyer will ask questions, and you'll have to show that you were first to market on certain things. But most of the time, if you have done a search and it doesn't show that anybody has ever filed it, it's unlikely that you're going to hit any big speed bumps along the way. Usually you'll get a letter saying it's being published. 30 days later, they'll say no one's objected to it. And then, boom, within, a couple of months, it'll be fully marked. Now, in the meantime, while this is all pending, you could still say that you're trademarked. You are now reserving your right to use this name as a trademark. So you can definitely, start using the name and proclaiming that you are protected under the trademark. Now, remember, if you didn't do it under 1A or TAS Plus status, that means you haven't used the mark in commerce yet. The attorney is going to reach out to you, and you have a certain number of months in order to respond to the attorney and provide the information that they need to show that it is now in the stream of commerce. And then boom, you'll then start. Then they'll publish you, and then you'll be 30 days for people to object, and then you're in business. So you really just want to make sure that when you go into this, what type of status you're going to be going in for. So that's basically it, guys. It's a really easy process, very, very simple to do. It just takes, whatever amount of time it took to discuss it in this video. But yeah, so you could definitely do it on your own, save yourself some money. There's a lot of opportunistic people out there that will try to overcharge you. Look, I mean, the easy part is this. This is easy, right? This is filing, and protecting yourself. The times when you may need a lawyer, or when you really want to, push the fact that you want to protect your name. That is, issuing a cease and desist letter, reaching out to another company or another individual and say, hey, listen, I was here first. Your name sounds way too much like my name. So that's when you might need a lawyer, or when you want to get a lawyer involved. I mean, technically, again, you could try to do those things yourself. It's just really writing a letter. But after they say no to you, then you're sort of at that point, your back's up against the wall, and you might have to, hire a lawyer. But having the trademark and having that protection, with that little R, or the little TM at the end of your name, it goes a long way in, scaring people off. And it will also prevent people from trying to be opportunistic and try to squat on your name. Now, squatting is not permitted, but people still do it. People will go on and, buy the name Lawyer of the Apes before I buy the name Lawyer of the Apes and say, oh, or buy lawyeroftheapes.com and say, oh, well, I'm going to squat on this. That is another thing. And cyber squatting is really, there's a lot of case law on that. So, and if you have a trademark name and someone's trying to cyber squat on a domain, there are arguments that could be made that you could, get that name from them. There's a lot of history where people tried to do that with, real corporations. I forget if it was Coke or Pepsi or some, I know it was some soda brand not too long ago. Somebody screwed up, I think, and forgot to re-up the domain name, and somebody bought it and tried to squat on it for a couple $100,000 to try to get them to pay. And in the end, they lost. They were the courts were like, no way, you're not gonna pull that. It's an interesting case. I forget the exact company, but it happens. It happens all the time, and the courts don't really stand for it. So it's still important to protect your name. I hope this video was helpful to you guys. I really appreciate what a lot of the individuals on social media have been doing for the ape community. This is not legal advice. It's for informational purposes only. You guys get that. It's not financial advisors, but I hope this does point you in the right direction. And even if you don't, use this video to actually, trademark your name yourself, I still highly recommend, just from a personal common sense perspective, that you should trademark your name. I don't care what anyone else has told you, you have to protect yourself. You're your most important investment. And this is definitely something that's inexpensive, not very time consuming, and you could and should be done sooner rather than later. So if you have any questions, never hesitate to reach out and sneak into my DMs. I'm also going to be popping up on some Twitter spaces. So if anyone ever has any questions in relation to this type of information or related to the litigations pending against with AMC and GME, never hesitate to contact me. I'm always here for discussion. And with that, until next time, the Lawyer of the Apes is adjourned.